Next case on the docket is Benjamin SAENZ versus PATCO Transport.
May it please the Court, my name is Bill McCabe. I represent the appellants, Mr. and Mrs. SAENZ. Seated at counsel's table is Chad Lawrence. He's the trial attorney. In this case, the trial court dismissed with prejudice Mr. SAENZ's complaint on the grounds that he perpetrated a fraud on the court. We submit the trial court has abused its discretion in dismissing this complaint. Dismissal with prejudice for fraud on the court is such an extreme remedy that the fraud must be demonstrated by clear and convincing evidence.
Mr. McCabe, Judge Perry wrote a rather lengthy order dismissing with prejudice, and in that order he sets forth a whole litany of facts that caused him to render that order. Which of those facts do you disagree with, or which facts in that order do you think are not supported by anything in the record?
We don't feel that any of the facts that he referred to is sufficient to dismiss this claim for fraud on the court.
Not even all of them taken collectively?
No, sir. And I'll go through them if I may. The first fact that he refers to, and I'd like to point out also, by the way, that there was no evidentiary hearing in this particular case. There was also no questions ever asked of Mr. SAENZ in his deposition or at any other time as to, or to try to explain what the defense felt were some of the inconsistencies in his answer.
Let me ask you this. I absolutely agree with you that if counsel below did not view the hearing that was granted as an opportunity for an evidentiary hearing, that he could have timely asked for an evidentiary hearing and would have had a right to have one. There's no question about that. The problem I have with your argument is that, to me, I just don't understand how you can go to a noticed hearing, not present evidence, when I think arguably you could have, because there was no prohibition. I mean, there's nothing in the record that I saw that said there was, he was denied an opportunity to present evidence, and not ask for. The record doesn't show that he asked for an evidentiary hearing at that hearing. Wait for a ruling, and then say, "Well, I don't like the result. Maybe I should try a different tactic. This time, I'd like to present evidence since it didn't go my way," which seems like what's happening. So even if you have a right to present evidence, can't you waive it by not timely requesting a right to present evidence, or not doing it when you have an opportunity? And why didn't that happen here?
Well, unfortunately, the actual hearing itself was not recorded. There wasn't a court reporter there, so we're really not sure what happened at that particular hearing, at least as far as the record is concerned. But the notice of hearing that went out that gave no indication that this was going to be an evidentiary hearing. He did ask for a hearing, according to this record, within a few days thereafter by way of a motion for a hearing.
After an order, correct?
Yes. But even at that, this case also has no deposition or anything in there where Mr. SAENZ was ever questioned about any alleged inconsistencies or deficiencies in his answer. So whether there's an evidentiary hearing or not, where's the evidence to support a conclusion that any purported failures was intentional, an intentional scheme to defraud the court?
If you've been treated for years by numerous doctors, and you get an interrogatory that says list all treating physicians for all these years, and you list only one, I have a hard time understanding how that's not intentional.
Well,
I mean, how do you accidentally miss 15 doctors? 11 to 15, I think was the number.
Well, it's supposed to be a scheme to defraud the court or to hamper the defense in the preparation of their case. I mean, that's what it's supposed to be before you're going to impose the drastic remedy of dismissing a lawsuit. And incidentally, this is one where they admitted liability. The sole question is damages. But in that same interrogatory, so let's look at the whole picture is what I think the courts are supposed to do. That interrogatory, he also indicates that he did have 3 other motor vehicle accidents, the one in '89, the one in '96, and one in 2002 when there weren't any damages. When his deposition was taken...
But he didn't say in his interrogatory answers there were injuries from any of those accidents, did he?
I'm not sure if the interrogatories asked that.
Okay, but if you say look at them in a whole, the whole is I've been treated by one doctor, I was in 3 accidents. How does the telling him I was in 3 accidents give any hint that, oh,
by the way, I only told you about one doctor, but there's really 12.
Well, his deposition was taken 2 months later. In the deposition, he testifies as to the injuries that he had in the '89 accident, where he had surgery on 2 shoulders and he had surgery on his low back. He testifies as to the '96 accident, where his main injury was a neck injury, which is exactly what the medical records show. He testified that in 2000 he went back to Orlando Orthopedic because he had complaints of pain in his neck, which is what the records show. He explained his workers' comp injury at Walt Disney and how he had surgery on his left shoulder. He also indicated the names of a couple of doctors that treated him in '96. He couldn't remember the others. He said he had the MRI, which showed the herniated disc at C6-7. Couple that with the fact that his attorney in this case, before the complaint was even filed, was sending letters out to old doctors, to insurance companies that handled the '96 and the '89 claim to try to get medical records. He sent those records to the adjuster before the complaint was ever filed, the records that he had.
Well, that sort of cuts both ways, though, doesn't it? If what you're saying is his lawyer was writing to all these doctors to get medical records before the lawsuit was ever filed, how in the world does he file a set of answers to interrogatories which only list one doctor that he was treated by?
Well,
why isn't that some evidence of fraud on the court if the lawyer knew there were other doctors involved because he was writing to them to get records?
Well, again, it kind of gets back to the fact that no one ever asked the claimant that, or Mr. SAENZ that, excuse me. He was never deposed and said, even in his deposition, he was never asked, why did you just list one doctor in your interrogatories? I don't know. We don't know why.
What would be the potential answer that could justify that if the lawyer knows there's other doctors because he's been writing to them pre-suit to get records? What possible answer could the plaintiff give if we know the lawyer knew there was so the lawyer must have known that it was an inaccurate answer?
If the answer is inaccurate, it was supplemented quickly and repeatedly with information not only as to the names of the doctors, but actual medical records from the doctors. And what's also interesting in this is the composite to which the judge refers to in his order for Mr. SAENZ not revealing all of his doctors and the carrier finding out who the doctors are. She is using consent forms signed by Mr. SAENZ so she can write to these doctors and get the medical records. Of course, she's already got them, but I guess she wrote to them again. I don't know. But it's in her appendix. The front sheet before the medical records has releases signed by the claimant. So is this a scheme to defraud the defense in the court? No, it's not a scheme. They got all the records. Was the answer to the interrogatory correct? No. But was it cured and corrected by providing other medical records? Yes. Now the second, so that's the answer to the interrogatories one. The other basis, or a second basis, that the trial court uses is that SAENZ allegedly made numerous denials of prior similar physical complaints. The trial court makes a finding that Mr. SAENZ denied any major injuries from the prior accidents concerning his shoulders or rotator cuff. There's no evidence to support that. He revealed in his deposition his surgeries to 2 shoulders in '91, his surgery to his low back in '92. He reveals the surgery on his left shoulder.
I thought the main issue there was that he denied having any prior injury or problem with his left hand, and then they found medical records showing that he had repeatedly complained about numbness, tingling, and issues with his left hand.
Well, there are some medical records in 2000 about complaints of the left hand. However, he's not claiming any left hand or left shoulder injuries.
Well, now he's not, but...
Pardon me?
I said now he's not.
No,
but
he never was. The answers to his interrogatories, those same interrogatories that were filed before his deposition, he's asked to list the injuries that he's claiming from this accident. There is no claim for left shoulder, left arm, or left wrist injuries. Now, in his deposition, counsel asks him if he thinks his left shoulder is a result of this accident and so on, and he says he did because he had left shoulder surgery at Walt Disney World from that comp accident, and then he was able to go back to work, and now after the car accident, his left shoulder's hurting again. But in his interrogatories, he doesn't claim it. And then when the demand letter went out by his attorney in March of 2006, there's no claim for left shoulder, left arm, or left wrist injuries.
Excuse me. Go ahead, finish your...
Well, I was just going to say they refer to Dr. Weber's deposition, which was in October of 2006, where when they start asking Dr. Weber about left shoulder problems, counsel for Mr. SAENZ says, we're not making any claim for left shoulder injuries. They indicate that that's the first time that was stated, but it's not. The demand letter went out in March of 2006 with no claim for any left shoulder, left arm, or whatever. So in civil litigation, it's got to be a material misrepresentation for it to constitute fraud on the court. If you're not making any claim for left shoulder, left arm problems, it's not a material issue. It's irrelevant and wouldn't constitute the basis for a dismissal. Yes, sir.
Counsel, if the court determines that there's some inconsistencies, let's say, in the testimony on a deposition and the answers to interrogatories, who has the burden of explaining why those inconsistencies exist?
It would seem to me it would be on the defense.
Why?
Because they are the ones that are trying to allege. It's the burden of proof would be on them. They're the ones that are trying to convince the court that there's an unconscionable, intentional scheme to defraud the court or hamper them in their defense.
It seems to me that if they present all of these inconsistencies to the court, and the court can then take a look at that and the totality of them and make its own conclusion, why do you have to have any additional evidence at all to explain them? If there are inconsistencies and there's no way you could possibly justify the answers that you gave.
Well, I mean, again, when you say all these inconsistencies...
Well, Judge Perry has listed 4 pages of them.
But the one doctor in the interrogatories is accurate, but I've attempted to explain that one away. The finding that he failed to reveal prior injuries is not supported by the record. And to the extent that there's the left shoulder, left arm discrepancy, it's irrelevant because he's not making any claims. Then he makes another finding concerning Mr. SAENZ's purported misrepresentation about his prior work history. There's 2 bases for that in the order. One is this job that the Mr. SAENZ had with JHI Inc. and why he allegedly was terminated from there.
I just have a hard time accepting the proposition that it's up to the defense to explain these inconsistencies. It seems to me when they point them out to the court that the plaintiff then has the burden of showing why inconsistencies exist.
Well, I mean, like I say, to me it seems if the burden of proof is on them, they have to show that there's maybe forgot. I mean, how do we know that? When is
I would agree that no explanation was given, or if it was given, there's no transcript of it, so we don't know one way or the other.
Well, there wasn't an explanation given because he was never confronted with it. He was never asked. And it would seem that if the burden of proof is on them to show that any discrepancies or omissions...
Well, how do we know he was never asked if we don't have a transcript of the noticed hearing?
Well, I think, for purposes of an appeal, aren't we limited to what's in the appellate record? And there's nothing in this record.
Yeah, but at this stage, you have to demonstrate error based on that record. And if you don't bring us a record on which you demonstrate that there's error, I mean, you can't ask us to presume that things happened at a hearing where we don't have a transcript in order to support your argument.
Well, there was no evidence presented at the hearing, and there was no court reporter there.
There's a presumption, though, that the judge's order is correct, and it seems like you've got the burden of overcoming the presumption of correctness.
Well, there's nothing in this record that shows any misrepresentations were intentional and in a scheme to defraud the court. I mean, when his deposition was taken, he was on medications. He says at the end, too, that he forgets things.
Let's go to I tell you, one of the even more concerning potential misrepresentations to me, because it does seem material, is the Disney matter. I mean, as I understand the record in the trial judge's findings, Mr. SAENZ said that he had an injury at Disney, admitted that, but said that it was corrected with surgery and whatever rehabilitation, and said that he was perfectly fine after that, able to work without any limitations until this accident. And then it was determined through additional discovery from him that he actually, after those surgeries, went back on a limited work schedule because of the physical problems that he was having. How is that not material, and how is that not significant as a misrepresentation?
Well, first of all, again, point out that the injury at Disney is a left shoulder, which is not a claim here. But secondly, when he was released to return to work on July 22nd, 2003, I think that was here, it was with no restrictions by Dr. Christensen. It's in the record. Now, yes, he goes back in November of 2003, and at that point, the doctor says, okay, I'm going to give you a 4% permanent impairment rating, and I'm going to give you restrictions of no lifting greater than 50 pounds and a couple things like that. There's nothing in the record, though, that indicates that that in any way affected his job. There's nothing in the record that shows that he did not continue to work at his regular job at Disney, full duty, until his automobile accident. Is that sufficient enough to cause dismissal of the case? Or if there is a discrepancy there, is that one of the areas where they can cross-examine him at trial and let a jury try to figure out if this man is trying to exaggerate?
And I guess the other question is, if we're having to grapple with, is that sufficient to support a dismissal, and the standard is abuse of discretion, if I'm debating it here, why shouldn't that be an affirmance, since we're supposed to defer to the discretion of the trial?
Well, does it, is this, I mean, dismissals are supposed to be granted cautiously and sparingly exercised, and only upon the most blatant showing of fraud. The cases where dismissals usually are granted are like the Cox-Burke one, which is one of, out of this court, one of the earlier ones, where the person used different Social Security numbers and different names. There's a Hutchinson case where the person alleged that he slipped and fell in an apartment complex and that was the source of his injuries, when he was actually bitten by a dog that he tried to hide. Those are the kind of cases where it seems dismissal occurs. This court's most recent decision, which we filed a motion for supplemental authority. We actually filed it twice because the first time we didn't have enough copies. But that's Gurman versus City of Orlando. It really seems like the court's trying to bring in the reins a little bit and re-emphasizing the fact that it's only the most blatant, egregious conduct that warrants dismissal. In this case, when they filed their motion for dismissal in December of 2006, they had all the medical records, they had all the information about his jobs, they had everything, and they had it at least 6 months prior to when they filed their motion to dismiss. So we just submit that this is not the type of egregious case.
Well, tell me why that's necessarily relevant. I mean, if you follow that argument to its legal conclusion, if the other side does enough digging and finds out all of the misstatements or lies by the plaintiff, then they can't get dismissal because now they have it all. And
No.
What's the consequence of the plaintiff having not revealed it to him or lied about it?
The records were revealed by the plaintiff in this
So
case.
the rule should be, if the plaintiff ever fesses up, then it's not dismissal, so I can misrepresent it in interrogatories, but if you set me for deposition and ask the right questions and I say, okay, you got me, now you can't get dismissal because at least by round 2 or round 3 or round 4, I admitted it? Is that the standard?
No. I mean, in an ideal world, everything comes out immediately. But to justify dismissal for fraud, there has to be an unconscionable scheme to defraud the court or the defense. When you take the totality of the picture, in this case, when the plaintiff is continually providing medical records, signing authorizations for them to get medical records, it doesn't justify an unconscionable scheme to completely permeate the truth of the matter. And it doesn't warrant dismissal. Thank you.
Got a little over a minute left for rebuttal.
Thank you.
Good morning, Your Honors. My name is Jennifer Moorhead, and I represent the defendants in this case, and I was the trial attorney in this case that filed the motion. I just first want to say that our system of justice doesn't expect every plaintiff to remember each tiny minutia of insignificant activity that happens in their lives, as seen in the case that was recently ruled on here. That plaintiff forgot 2 very insignificant things that happened to him years and years prior that were of no consequence. And we don't sanction or punish people that fail to recall insignificant, isolated events, or that fail to remember things that were so remote they were too remote to be relevant, like the case where the 72-year-old couldn't remember something that happened 35 years prior. No reasonable person would expect that. And that's the standard of review. The standard of review is abuse of discretion, and abuse of discretion is, did the court reach a decision that no reasonable person under the circumstances would reach? The other thing is, we also don't penalize people for truthfully saying, you know what, I don't remember, or I think, or maybe giving an equivocal answer, like the lady in Ruiz, when she said, I don't remember the name of the doctor, but I can get it for you because I've got the records at home. That's not, to dismiss something for abuse of discretion like that, that is abuse of discretion. But that's not what we have in Mr. SAENZ's case. There's a bright line that's drawn. If you look at the history of all these cases that have to do with dismissal for fraud, there is a bright line there. And the bright line is when the plaintiff makes a definitive statement, and that definitive statement goes to the heart of the matter and is sufficient enough that it is more than just one minor thing, then the plaintiff forfeits his right to come to court because he has basically played the system. Like when I said in my brief, this is not a game. This is not a game where your first effort is, well, in answer to interrogatories, I'll just give you maybe 1 or 2 things. And then in deposition, I'll give you something else. And then in deposition, I'll claim everything I can possibly claim. And if you find it,
let me ask you to address the argument that the misstatements regarding the left arm, left hand are not material because the plaintiff was never claiming any injury in this lawsuit to the left arm, left hand, and so that can't be the basis. Any misstatements regarding that issue can't be the basis for a
well, the
dismissal.
fact is that this kind of fraud on the court is not based on the attorney. It's based on what the plaintiff has said. He's the one that comes into court. He's the one that holds his hand up and says, I swear to testify to the truth. And in his deposition, I asked him from head to toe what he thinks is actually related to this incident. So he said in deposition, his left arm in 2 places in his deposition. He said his left shoulder in 4 places in his deposition. He said his low back in 4 places in his deposition and interrogatories. Both legs, both knees in 3 places in his deposition and in his answer to interrogatory. His right wrist, right hand, carpal tunnel problems in his answers to interrogatories and deposition, and his right shoulder rotator cuff, both in his depositions, answers to interrogatories. The list was in his deposition. It is his claim. It's not his lawyer's claim. It's his claim, and he's the one that lives it. He knows his life. His lawyer doesn't have to remember that for him. He is required to come in and answer interrogatories and answer in his deposition with complete candor for what he remembers. And that's what I asked him, and he specifically listed all of those. And I listed them for you in my brief, A through F. And he denied any kind of numbness or tingling in the left arm that he had complained about that was part of this suit. And he denied having any left carpal tunnel syndrome in his left arm. That was his complaint in deposition. And we found twice in the records of Dr. Brooks and Dr. McBride where not only was he complaining specifically of numbness and tingling in his left arm, hands, and fingers, but they sent him to an EMG and a nerve conduction study that showed he had carpal tunnel syndrome. So he has specifically denied these things in his deposition.
Counsel, let me take you back to your originals. I want to make sure I understand. You're not suggesting, are you, that our standard of review is anything other than abuse of discretion, are you?
Right, it's abuse of discretion. It is abuse of discretion, but
And what does that mean?
that means that the court has made a ruling that no reasonable person would make under the circumstances. It wasn't cited in the brief, but it's Boca-Berger versus Forum.
I thought it was that no reasonable circuit judge or trial judge would make that ruling under any
It says a
circumstances.
result no reasonable person could adopt under the circumstances is the definition in the Supreme Court case. So,
Let me focus on the first issue, which is the interrogatory answer and the one doctor that was revealed. This seems a little different than some of these cases we see factually, because there appears to be evidence that you must have known from the get-go that that was incomplete, that there were other doctors involved, that there were records being obtained, that there were consent forms being provided. Is that accurate?
well, I mean, in actuality, when I get a file as a defense counsel, I don't always get everything the insurance company has or may have. So what I saw in the answers to interrogatories was that he had one previous treating doctor, he had some previous injuries.
Are you telling me you don't get the claims file?
Well, I get
Don't have
parts of the
communication
claims
with the-
file, but I don't always get everything. I have to constantly call them and go, well, did you get this? Did you get that? Give me some more information, because they don't
But I
always
mean, the question
give it.
was, I mean, I would think, given the record that we have, and given what trial counsel had given to the claims adjuster pre-suit, that you would have known as soon as you got that answer to interrogatory that there were additional doctors. Are you telling us you didn't know that?
I didn't know the extent of the additional doctors.
But you knew there were additional doctors.
I knew there had to be, because one of the things I got was that he had filed lawsuits up in New York. And we got copies of the lawsuit, and some of the orders in that lawsuit had listed, these are the doctors that I expect to testify, boom, 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 boom. So I knew that there were some doctors there. To what extent or what they were about, or whether they were treating him for injuries that were pertaining to this, I didn't know actually until I started asking him in deposition. And then I got specific while I was asking him in deposition, because I gave him several different questions that were geared to say, come on now, you did specifically, didn't you, have these claims? And he kept denying them. He denied them, constantly. And so, and with regard to that too, the plaintiff has, in answering interrogatories, there's a rule that says you have to answer them fully, which he did not do. And the other rule is I think it's section C, which says if there's so many that you can't remember or whatever, you can provide records. But it says in that rule that you have to indicate in the interrogatory with specificity of the doctor, the names and addresses, so we can find the record to say if you want to rely on the record. Neither of that happened in the interrogatory answers. The other thing that happened in this deposition was they did not waive reading and signing the deposition. And I did not file this motion.
I guess the point is, why isn't it inconsistent with your claim that there was a sentient, unconscionable scheme calculated to interfere with justice or unfairly hamper you? Why isn't everything that the attorney did inconsistent with your claim that there's a basis for fraud? I mean, I'm somewhat sympathetic to that argument, at least. I mean, the attorney's pre-suit given your client all sorts of medical records, access to medical records, information. I mean, to me, that says we're trying to be forthcoming. So how does that affect the analysis of this legal issue, whether it's appropriate to dismiss for fraud when in light of those circumstances, the plaintiff himself comes forward and perhaps lies in deposition, gives incomplete interrogatory answers that are perhaps misleading, and does other things that, absent that, might be enough to dismiss?
Because this type of dismissal has nothing to do with what the plaintiff's attorney's ethics. It has everything to do with the plaintiff and what he swears to. The plaintiff's attorney is not the person that gets up and testifies in court in front of a jury. The plaintiff's attorney's actions are not what is at issue here. What is at issue here is the plaintiff himself, who lived it, who swears to tell the truth under oath, and then is supposed to do that under our system of justice. That's why it's not the activities, too, that happen pre-suit or during negotiations with attorneys or insurance companies. Those aren't things that are before the court. What's before the court is the plaintiff's testimony. What's before the court are answers to interrogatories, depositions, affidavits. That's fraud on the court. And that's what is in the court's purview. This has to do with the plaintiff, not his lawyer.
Let me ask you this. Given the case law saying that a plaintiff has a right to an evidentiary hearing if there are factual disputes regarding the fraud and his intent or her intent, why shouldn't we send this back for an evidentiary hearing?
He did have an evidentiary hearing. That 5-page order says in the footnote that the judge heard all the evidence presented by both parties. That's what's in the court record. He had an evidentiary hearing. The hearing notice was sent out 30 days before, I think, between 25 and 30 days before this case was noticed, before the hearing was supposed to be had. If during that time he thought that, oh my gosh, this is not an evidentiary hearing, he has 25 days to ask the judge for additional time so that he can have an evidentiary hearing. That didn't happen. What's in front of the court is the record that shows that actually he knew there was going to be an evidentiary hearing. Because between the time of the motion and the time of the hearing, both I and the plaintiff's attorney filed memorandums of law with giant stacks of evidence that we sent to the judge. He knew there was going to be an evidentiary hearing, and the judge heard evidence. The case is
what part of the order dismissing with prejudice do you contend indicates or references that the court actually took evidence or held an evidentiary hearing?
There's a footnote in the order. Besides the fact that it's a 5-page...
I see some footnotes, but I don't know where... I mean, one footnote is a factual issue. One says the defendants are not seeking dismissal of somebody else's action, and the next one says the court will utilize the exhibits provided by the parties in their memoranda. Is that the footnote you're making reference to?
Right. And the fact that the court did a 5-page order that sets out all the evidence and all the facts. I mean, this was a very well-reasoned order on this issue. And the judge took a lot of pains to make sure.
But the facts he sets forth are from depositions, they're from interrogatories, they're not from, I heard testimony. There's no indication there was testimony taken at this hearing, correct?
No. It says that he considered the evidence provided by both parties.
Counsel, could you comment on Mr. McCabe's position that you've got the burden? In other words, if you go into this hearing and you present a deposition and then an interrogatory that's at odds with that or whatever other testimony that's in written form, but the judge has it in front of him, that shifts the burden to you to explain why there's an inconsistency?
No, actually, it's his burden. If you look at the case law that involves this, the ones that have been ruled on with regard to that issue where they have overturned the dismissal for fraud have to do with the fact that the plaintiff files before the hearing an affidavit that explains or somehow justifies the inconsistencies. And he had every ability to do that because there was 30 days between the time. He also had every ability to do that, to sit down with his lawyer, reread his deposition, change it if he wanted to change it. For a year. There was a year between his deposition and the time I filed this motion. In that time period, he could have corrected anything he wanted to correct to make sure that he was, giving the right, correct information in his deposition. He didn't do that. And before the hearing, there was no affidavit to explain or otherwise say anything that justifies this. That's their burden. And
Well,
that
wait
was
a minute. The
case to
ultimate
show
burden
the
is
plaintiff.
yours, right? You're the one who filed the motion. You're the moving party.
First.
You move to dismiss, you've got to meet your burden, right?
Right, then it shifts to him. Then it shifts back.
Well, what do you say creates sufficient evidence that shifts the burden to him? And is there any case law that says these kind of cases involve shifting burdens? Because in most cases, the movement has the burden and they keep the burden throughout the event, and it's only in sort of very specific circumstances where the courts have recognized that the burden shifts back and forth. Is there any evidence or any case law to indicate that in these kind of cases there's a shifting burden of proof?
Well, when you look at the cases and the facts in the cases, it does. Because this kind of thing doesn't have, it's not about the subjective intent of the plaintiff. It's about the facts and circumstances of the case that prove the fraud. And so when you look at the cases that have overturned them, there's like 20 also that have overturned them. There's something like 27 that have upheld them. When you look at those cases and you look down through them, you see that what happens is that the plaintiff says, for instance, well, you know, they filed an affidavit that said that was so long ago and so insignificant I forgot. Or, you know, they actually file affidavits in support of or in objection to the motion. So it just shifts back naturally once I meet the burden about their lives. And he didn't say that. He can't say that. He can't say that these are insignificant. There are 17. Well, depending on how you count them, there's 11 to 16, I guess, I think was actually the
Let me have you address one that we haven't talked about yet. As I understand it, there was some dispute or some issue about when he was terminated from a job and whether it was because of a failed drug test or some drug problem, and whether he was talking about a different employer than you were talking about. Can you address that issue?
Yes, sir, I can. That was, when I read that, that was just amazingly disingenuous to me, because it was the plaintiff's own testimony in his deposition, at page 46 and 47 of his deposition, that JHI and Mater Company were, in his words, one and the same. He was working at JHI, his paychecks were coming from Mater. And his deposition, he tells me they are one and the same. And then he tells me he worked there for a year, and oh, well, he just left because they didn't have good benefits. Well, the records from Mater show that that's not true. He didn't work there a year, he worked there a month. And he didn't just leave, he was fired for failing to comply with a drug-free workplace. That is significant to go to his issue of workability. Just like the fact that he did come back and right before this accident was working under restrictions, that is significant to his work loss claim because it is significant to his workability. He did not, as he tried to tell me, go back to full duty work without restrictions and was at full duty work without restrictions before this incident happened. That is wrong. That is in Dr. Christian's records, and that is in the Disney records. And it wasn't just that he went back to Dr. Christian and said, and Dr. Christian just kind of gave him this restriction. He went back with complaints. And that record shows, in the subjective part of that record, he complains of these problems and he doesn't think he can go back to work full duty. That's the plaintiff complaining to the doctor, and so the doctor examines him and then puts him on restrictions, sends the note to Disney, and Disney says, okay, we'll keep him working under restrictions. That's where he lied. He lied several times. He lied more than several times. The list is just egregious. It's more than 90% of the cases that uphold a dismissal for fraud. There are more inconsistencies and more lies in this testimony than most of these cases. So, I think I've got like 10 seconds. So, if you don't have any more questions, I'm done.
Thank you, counsel.
Okay.
another minute of rebuttal here.
We've got a little over a minute, and I'd like you to address this employment issue about whether he was terminated from a job and whether he lied about that in his discovery.
What he says, he was talking about JHI Inc. Who's the owner? Don't know who the owner is. All I know is I worked for them. They were part of Mater Company, a big company that do drywall here. Mater Company and JHI are two different corporations. There's articles of incorporation for each of them in this record. The thing that's a little bit confusing about this is that there is a document in the record from Mater that states he was terminated on October 20th, 2000 for failure to comply with a drug-free workplace, which who knows what that means. But he also put in evidence or attached 1099 forms for the year 2000 and 2001 from JHI Inc. So how could he work for JHI Inc. in 2001 if he was terminated from them in 2000? And the question that was asked was, why were you terminated from JHI Inc.? So I don't know. There's some confusion there. But again, no one was ever asked him to try to explain that or whatever. He filed an affidavit in his motion for rehearing stating that he was let go or he quit JHI Inc. because there were no benefits. The burden, I guess I'm over. Sorry.
Thank you.
Thank you.